arbitration clause to that effect in this court will be the first finding in this court in the meaning of condone for this purpose, and will be, if it's made, an important finding. Finally, I will deal briefly with the question of aggregation, but I'm not proposing to spend half a day on that. And the short answer to that, although there is a longer answer, but the short answer in our submission is that the acts, the dishonest acts which gave rise to the surplus funds claim were not similar to the dishonest acts which gave rise to the dragonfly claim, because the latter involved procuring a mortgage, whereas the former, and that procuring the mortgage was necessary in order to get the money which was then taken, whereas the former involves simply taking money from client account, pure and simple. Those are not similar acts, and what this policy, we would respectfully say what the aggregation clause is to do is, as my Lord Justice Phillips said in the course of argument, cases such as Woodman, where there are lots of acts which are almost identical or very similar. That's not this case in our submission.
You say it's not just good enough to say, well, it's two instances of stealing client monies, because the transactions have to be related as well.
Yes, the relationship submission is slightly longer, so I'm not going to try and summarise it now. But
you say it's not enough to show similarity for the purposes of the accumulation clause, that they are both essentially what has happened is that client funds have been stolen. That's too simplistic, you say?
Yes, as the judge said on his evaluative decision, you've got to get into the detail to at least some degree. I mean, in the last minute, I haven't got into much degree of detail, but it's already enough to show that they're not similar. So we're not suggesting incredibly painstaking definitions, just a basic description of the two claims.
You say, well, whilst they arise out of the same context, they are two very different frauds.
Yes.
Actually, one is purloining the monies in the client accounts, just simply taking them, and the other is the rather extraordinary process of applying for a mortgage through a stooge, to obtain monies which are not, as it were, client monies ab initio, but are monies obtained from a lender, which then, when they become client monies, are then stolen. Exactly,
my lord. That's a different project from the fraudster's point of view, from simply authorising the removal of money that's already been paid on a legitimate basis to client account. So, my lord, that's the structure which I'm going to try and stick to. So could I begin with the context of the policy? And I'm looking here at our skeleton, paragraph 11. And as I say, I'll take this quickly because it may well be that it's very familiar to some in this court, possibly even all. But this policy was written pursuant to what amounts on the impact case to a statutory scheme which regulates the provision of the primary layer of professional indemnity insurance. That's the first 2 million for partnerships, first 3 million for LLPs and companies, for solicitors practicing in England and Wales. And we'll see in a moment there's a similar scheme in Northern Ireland. And the power is given to what's now used to be Law Society, now the Solicitors Regulation Authority, pursuant to Section 37 of the Solicitors Act 1974, to require solicitors to take out insurance. And at the time when this policy, incepted on the 1st November 18, the relevant rules issued by the SRA were the SRA Indemnity Insurance Rules 2013, and Rule 4.1 required any solicitor practicing in England and Wales to take out a policy which was issued in accordance with these rules. And incidentally, the list of insurers, it doesn't really matter for today's purposes, but there was a list of insurers who approved to write this cover by the Law Society, or SRA rather, to some extent. And that policy had to comply with the SRA minimum terms and conditions, excuse me, which appeared at Appendix 1 to those 2013 rules. And in particular, Clause 6.8 of those, as we'll see, allowed the insurance to exclude cover in circumstances referring to condonation. And the wording of that clause is similar, but definitely in our submission not identical to Axis's wording. Now, those minimum terms were minimums. That was the minimum level of cover that the insurers have to provide. And many of the traditional remedies used by insurers for not having to cover claims are not allowed by those rules because they are enacted by the SRA for the purposes of protecting members of the public who use solicitors in relation only to the primary layer. Above the primary layer, there can be all sorts of reasons for not covering the claim. But what the minimum terms do not do is say that the policy must be identical. All they are is a minimum, a floor, as it were. Insurers can have cover that's more generous than the minimum terms. Now, my lord and my ladies, the Supreme Court, this is paragraph 12 of our skeleton, considered, as you've heard, the construction of minimum terms in the impact funding case, which we looked at briefly yesterday. That's tab 8 of the authorities bundle. And the main point I want to make here is that the court held there that the principal purpose, sorry, I'll just wait for a moment, tab 8, the principal purpose of the statutory scheme of insurance from the Solicitors Act is to protect members of the public, like my clients, who are the clients of solicitors. And could I ask you to turn to page 80, letter H, in the judgment of Lord Hodge, with whom Lords Mann, Sumption and Toulson agreed, and paragraph, so if we turn to page 80, paragraph 11, Lord Hodge sets out what I've just related, really, the statutory, the insurance rules, in that case the 2009 rules, in our case the 2013 rules, Solicitors Indemnity Insurance rules, were made by what was then the Law Society, now the SRA, in exercise of the statutory power under section 37 of the Solicitors Act. This was there was thus a scheme of compulsory professional indemnity insurance which Parliament had authorised. Dropping to paragraph 16 at the bottom of page 80, letter H, Lord Brightman, in Swaying the Law Society, described the context of the statutory scheme of compulsory insurance. In exercising its power under section 37, the Law Society is performing a public duty, a duty which is designed to benefit not only solicitor principals and their staff, but also solicitors' clients, like my client. Over the page, the scheme is not only for the protection of the premium-paying solicitor against the financial consequences of his own mistakes, mistakes of his partners and mistakes of his staff, but also, and far more importantly, to secure that the solicitor is financially able to compensate his client. Indeed, I think it's clear that the principal purpose of Section 37 was to confer the Law Society the power to safeguard the lay public, and not professional practitioners, since the latter can look after themselves. We go to page 87B, please. This is the judgment of Lord Toulson, with whom the other judges also agreed. And as he says in line 4 in paragraph 41, as the House of Lords recognised in Swain, the paramount purpose of the Law Society being given statutory power to require solicitors to maintain insurance cover against professional liability was the protection of that section of the public that makes use of the services of solicitors. So, and the judge said this, paragraph 17 of the judgment, the policy has to be interpreted in light of that principal purpose. That's not the only consideration, as I'll submit in a moment. Now, Axis submits also on the basis of this impact case that an exclusion clause should not be construed narrowly in favour of the insured, and we accept that. It should be construed neutrally. Turning now, please, to a similar case, could I ask you to turn to tab 21 in the authorities bundle? I'm afraid I've only got one authorities bundle, so I don't know if your volume 2, but it might well be if you have to.
Sorry, which tab?
Tab 21, please.
Thank you.
Now, my lord and ladies, this, I am in accordance with the practice direction, giving you the only reported version of this case, but the type is very small, and so we've also given you the transcript, which has bigger type, and that's probably all we need for today's purposes. This is a case to which my Lady Justice Andrews was party, I believe. It's the case of Tuans judgment dated 31st August this year. I wish to refer, please, to paragraph 52 and following under the heading "The Policy Wording" in the judgment of Lord Justice Popplewell, with whom both Lady Justice Andrews and Lady Justice Fulk agreed. Now, it's fair to say this case concerned a Northern Irish policy, but it appears from 52 and 53 that the scheme, the statutory scheme, was the same, essentially, in Northern Ireland as in England and Wales. And at 53, there was an insuring clause which referred to an exclusion for any individual committing or condoning dishonest or fraudulent conduct. So it's similar to our case. I should say condonation was not an issue in this case. What I want to refer to is 2 points which Lord Justice Popplewell made. It's our submission that these points are also relevant to the similar policy that we're concerned with in England and Wales, because the court was construing the same sort of statutory scheme for the protection of the public. At 54, Lord Justice Popplewell said that 3 matters deserved emphasis. The first was the insurance clause was in very wide terms. He then went on to say that this is consistent with the function of compulsory professional indemnity insurance for solicitors, an important aspect of which is the protection of the public, and he reiterated Lord Brightman's dicta that I've just read out in the Swain and the Law Society, and reiterated the point at the end of 54 about it being important that the solicitor is financially able to compensate the client for any liabilities found to be owed to the client. He added at 55 that the exception, that's to say the condonation, as it were, exception, makes clear that unless the claiming assured has themselves committed or condoned fraud, the fact that it's the fraud of others which has given rise to liability is no bar to cover. And he added, that reflects both the inherent nature of this being a composite policy, which is a separate bundle of contracts in which the fraud of one insured doesn't affect the right of recovery of another, see Arab Bank, and the need for the protection of solicitors from the consequences of fraud by an employee or individual member of the firm, for which innocent partners will be vicariously liable to the client, as well as the protection of clients by means of derivative claims on the insurers, which is what we are bringing here. Our clients have a claim pursuant to the Third Party Rights Against Insurers Act. We stand in the shoes of Jirehouse, as against Axis, to be covered for the claim against Jirehouse. It is well known that such cases regularly occur and form a paradigm example of circumstances for which compulsory professional indemnity insurance cover is required and to which it responds. Now, Lord, as I and the ladies, I fully accept that condonation was not an issue in that case, but that's the general context that we're concerned with in construing this policy in our submission. As to, could I now ask you to turn briefly to tab 26, please? So this is an extract from McGillivray, the leading text, of course, on insurance law, and I'd like to refer to paragraph 19077 at the bottom of page 676, headed Effect of Fraud on Joint and Composite Policies. The fraud of one of 2 joint insurers, that's not our case in our submission, will defeat a joint claim by both. The fraud of one co-insured in making a claim will not defeat a separate claim by another co-insured, where the latter is not party to the fraud and has a right of claim not derived from that of the fraudulent insured. For example, in the situation usually labelled composite insurance, where there are distinct contracts with different insurers, albeit embodied in the same physical policy document. Could I also ask you briefly to look at tab 22. Now, this is the case referred to by Lord Justice Popplewell, Arab Bank, for the proposition that professional indemnity insurance is composite insurance. And Mr. Justice Ricks, page 272, discussed that point.
None of this is in dispute here.
Well, what is in dispute is whether there's a policy, what the policy is behind the condonation proposition. What my learned friend says in his skeleton, said orally, was that the policy was to protect insurers. What we submit is that the policy is, which is the policy I'm just coming to actually, that there's a fundamental policy of insurance law that you can't insure yourself for the consequences of your own dishonesty. And the issue that arises in this case is how does that apply where you have a company with two directors? And the submission that we make is that the context of this policy is that the reason why the minimum terms allows an exception for condoning by a corporate body is that if the corporate body is to be treated as complicit in the fraud, which gives rise to the claim, then that policy of insurance law applies, and the insurers don't have to cover the claim. So the issue is the corporate body complicit or not? And in the passage I'm going to take you to in a moment, what is said in the leading text, Cannon and McGurk, is that that line has been drawn for the purpose of the minimum terms in the way that is particularly favourable to clients of solicitors, no doubt for the reasons of the overarching policy that I referred to a moment ago. So, but I will, my lord, try and take this briefly and take the point that it's not greatly, it's partly.
Well,
so
is this leading up to an equation of the word complicit with the word condone?
it's the context, yes, it's the context of condone.
Because I'm just wondering, just to put this into context, we know that there's all this background says as a matter of principle. If it's a composite policy, then the innocent, let's say the innocent directors of the company, or the company won't be deprived of cover because one of the directors was fraudulent, unless the company as a whole could be said to have been party to the fraud.
Yes.
And the same would go for a partnership if the partners were not involved in some way in being complicit in the fraud. That's the position at common law. That's the background. But of course, that's all subject to contract. And aren't we ultimately construing the word condone in this context? And the quick question for us is whether condone equals complicity, in other words, being actively party to the matter, or whether it means something less than that.
Well, the answer is yes. You certainly are concerned with what condone means. It's certainly right that you have to look at it in today's case in the context of the actual words used by Axis. Yeah. Indeed, that's the basis of our respondent's notice. But you also have to look at what condone means as a matter of dictionary, all of which are points I was hoping to come to briefly, albeit briefly. But the background is that this is a professional indemnity insurance, so it is a composite policy. I don't think that's challenged, as I understand it. We didn't get agreement to the proposition Arab Bank, so it's gone in the authorities' bundles. It's not completely agreed, but it's rather vague what isn't agreed. It's just the background as to what the policy of insurance law is, and the policy is that in order not to be covered, you've got to be complicit, whatever that means, and the policy word. You've got to be complicit in the fraud, and the fraud is the fraud that gives rise to the claim, in our submission, not some generalised miasma of being up to no good. This is a claims-made policy, and as we'll see when we come to wording of policy, it's the claim that the policy focuses on. It's the making of a claim that triggers cover, and therefore the issue as to condonation is, was the condonation of the facts giving rise, dishonest facts, giving rise to the claim?
Does that mean that if it were proved in a hypothetical case, two-partner firm, partner A is regularly helping himself to money from client accounts, partner B knows perfectly well that he's regularly helping himself to money from client accounts, but it just happens that the complicit partner is out of the office on the day when he helps himself to money from a new client account, and that gives rise to a claim on the insurance policy that they can recover.
I would accept, I think this is an example raised by Mr. Lawrence in his skeleton argument below.
Oh.
But I would
Great
accept that the insurers in that case would be entitled not to cover the claim, but that's because on the strong facts of that example, there would be condonation through a pattern, very strong pattern. What I would submit is that in relation to condonation, I'm jumping ahead a little here, but it may be helpful. In relation to condonation, you've got to ask what does condone mean? It's got to involve some kind of approval in our submission, and that's what the dictionary says, and they appeal against that, some kind of approval of bad misconduct. Now, plainly, the first kind of condonation that could be would be express. I hereby condone Bloggins stealing money. Now, unsurprisingly, there are no cases of that kind, because no doubt fraudsters or even dishonest condoners don't tend to advertise what they're doing so clearly. I accept that, so I fully accept that condoning can take place silently and by conduct. However, in that case, it's a bit like a misrepresentation by silence. It's much harder, or it is less clear what the condonation is. If I say, I condone my pupil barrister misleading the court, clearly I've condoned wrongdoing. If I, on the other hand, merely sit back and do nothing when told that the pupil plans to do that, well then I can see I've condoned it by silence because of the pupil supervisor. I've got a duty to speak out. But what that shows you is that for the kind of case my learned friend is running, firstly you need knowledge, he says blind eye knowledge, of misconduct. Secondly, and I'll come on to the test for that, but that's the first step. Then you need a duty to act, and of course, generally speaking, I don't want to get too philosophical, but generally speaking, in tort, you have a duty, you're liable if you positively act, not for omissions. So it's usually harder to show liability for an omission, but nevertheless it can be done.
In this context, much harder, of course, when you're dealing with professionals like solicitors who do have duties.
I'm sorry, much harder or much
Much harder to say that you don't have a duty in a situation like this.
Certainly, in a strong case, like stealing client money, certainly a solicitor, I accept that, has a duty to act in relation to that. There's no doubt about that. But nevertheless, what is necessary to be done here is, first of all, to decide on Axis's case, did Mr. Prentice have blind eye knowledge? And again, I'm jumping ahead and I'm going to come back to this, but that requires a finding of fact about the subjective, not the objective, the subjective state of Mr. Prentice's mind.
Yeah.
There has to be, and oddly enough, when one looks at Group 7, actually what we did in that case was to refer back to the Star C, which actually, as I see, is an insurance law case.
Yes.
And it's about, of course, privity in the context of the Marine Insurance Act. It's about the ship owners allowing a ship to go to sea when they know it's not seaworthy.
Yeah.
That's the issue. And again, it's complicity. Did they know that they were sending their ship out to sea when it might well sink because it wasn't seaworthy? And what the House of Lords say, and we can see it from Group 7, is it's not enough to show gross negligence.
No.
It's not enough to show that any reasonable ship owner would have been bound to spot that it was not seaworthy. What's got to be shown is a subjective appreciation that, for blind eye knowledge, that there was a real risk that it wasn't seaworthy, combined with a deliberate decision not to investigate. Just like Nelson, in the story, he puts a blind eye to the telescope because he realises that what the message is going to say he doesn't want to read. So in other words, blind eye knowledge is very close to actual knowledge, but in order to assess whether there's blind eye knowledge, it's acutely fact sensitive in our submission. You've got, the trial judge has got to decide whether Mr. Prentice had those thoughts in his mind and made that conscious decision. That, in our submission, is the paradigm case of the sort of finding that should not be overturned on the basis of 3 hours submissions or 2.5, 3 hours submissions, looking at a tiny percentage of the 15,000 documents that were before the trial judge. But that's how Axis's case works. It's got to be blind eye knowledge, there's got to be a duty to act and a decision not to act, and furthermore, this is our submission as to condoning. If you look at the policy words, they do not say insurers can exclude cover if there's been condoning of some kind of practice which has some kind of connection to the ultimate matters which gave rise to the claim.
No, it seems to me that it's fairly clear that what must ultimately be found is that fraud was condoned. The question is whether or not knowledge of and approval of other acts in the same pattern amounts to condonation.
Yes, my lord.
Of the fraud, such that if
Yeah.
you know that somebody is regularly taking money from a client account,
Yes.
you may not know about this particular
Yes.
taking, but if you know it's been done regularly, you are condoning all takings.
If you don't act, I'd accept that, my lord.
Yes.
Yes.
Even if you think it's going to be paid back, and it has been paid back over a pattern of time.
Well, if there's a strong, clear pattern, I think the example given by my learned friend is 99 times there's awareness of money being taken, the 100th time there isn't. There's a clear pattern, nothing's done about it, so that condones a practice of taking client money. That's not this case on any conceivable view in our submission. What needs to be shown is condoning of the fraudulent act which gave rise to the surplus funds claim and the fraudulent act which gave rise to the dragonfly claim. Now, in theory, I accept that could be shown if one has the case of a partner of Mr. Jones who knows exactly what he's doing on multiple occasions and does nothing. I accept that would amount to condoning of those particular acts. That's what's got to be shown, condoning of those particular acts in relation to separately, in relation to surplus funds and dragonfly. And that's simply not this case in our submission. First, because you shouldn't, in our submission, overturn the judge's findings. But secondly, even if you do overturn them, we're not remotely close to the facts of the cases that set up this line of authority, Karim and Goldsmith-Williams. My friend actually accepts that in writing, as the judge says, that Karim is a very different fact. We'll come to that possibly tomorrow. When you look at Karim, you can see there's an absolute catalogue of failures. There are numerous SRA investigations, which, unlike in our case, don't result, as happened in two cases in our case, on the SRA taking no further action, but result in reprimands from the SRA. That case is where Mrs. Karim brought in her two children as partners, within about a year of them qualifying as solicitors, where they were living the life of Riley on a large income, which they knew on the judge's findings could possibly have come from the solicitor's firm that was paying them the money. So, I mean, I am going to make a submission on the facts of that case, but it's a very different case, even if you overturn the judge's findings, a very different case from today's case. But that's an example of the pattern. But the other submission I'm going to make, as you may have seen from our respondent's notice, is that actually when you look at Axis's policy, the course of conduct reasoning set up in Karim, which was well known to those geeks who practice in this area by the time Axis wrote their policy, referred to in the main textbook, Cannon and McGarr, they chose not to use that wording. And when you read Karim, we submit, it's quite clear that the course of conduct construction is only based on the standard minimum terms wording. Because in summary, what the minimum terms say is condoning either a fraudulent act of remission or dishonesty. And what the judge says is, well, condoning a fraudulent act of remission, that's condoning the specific act that gave rise to the claim. Condoning dishonesty, that's condoning a course of conduct. What Axis did in this case was to delete dishonesty from their policy. Their policy doesn't use the dishonesty wording. It has to be construed objectively, so objectively, why did they delete the wording that's the linchpin to the course of conduct reasoning? We say, because objectively speaking, their policy doesn't use course of conduct as a basis for condonation. Yeah. I'm grateful. Yes, I see it's time for transcribers to have their break. Would you rise?
Very well. We'll rise for 5 minutes.
All rise if able. would like to let everyone know the live stream is still on. It started working again, so if it was working for example,
Yeah, thank you. That's helpful. Yes, I didn't realise that yesterday. So my wife pointed it out. Sorry, yes.
I was struggling.
I'm sorry, yes.
And the reading
yes.
specifically.
Reading, yes.
Yeah, I think this
yes.
microphone's not in the best place. I'm struggling.
Okay.
Sometimes it's dropping
Yes.
some of the words.
Yes.
I'm going to move it here.
Yes.
But yeah, especially the reading.
Yeah. Right.
Thank you so much.
Apologies.
you guys need to be done by 1.
We're stopping at 1 today and starting again tomorrow morning.
Okay.
Yep. We know where volume 2 is.
Stanley, can I ask what the name of the book you're referring to is?
It's Cannon, as in a gun, and McGurk, M-C, capital G, U-R-K.
Lovely, thank you so much.
And Tuins is T-U-G-H-A-N-S. T-U-G-H-A-N-S. And I'm going to refer to 2 cases later. One's called Volpi, and Volpi, that's V-O-L-P-I.
Volpi.
And the other one is called, has a Russian name, unfortunately. Just a moment. Yes, it's called Ablyazov. That's A-B-L-Y-A-Z-O-V.
Yeah, that one. Thank you.
Right.
Yes.
Yes.
That one.
It's familiar in the Court of Appeal.
Yeah.
Yeah.
Thank you. Just 2 volumes, and we have 1, which is fine. Where's the break?
authorities bundles?
Oh, I don't know because I thought it double-sided as
Right,
well. I'll have
okay.
to find out.
Thank you.
If it's the same as Patrick's,
Yeah.
16.
16. Thank you.
But I don't know that as a fact.
Noted.
Save trees.
All rise if able.
Yes.
Thank you, Lord. I must apologise to the transcribers. I must speak more slowly and will endeavour to do so. I wanted just briefly to refer to Arab Bank. The wording is different, but it does on page 272, bottom of column 1, just at a point marked by the head by Lloyd's Law Reports, say 4 lines from the bottom, or sorry, the last paragraph. In the present case, the policy goes much further than is normally done, at any rate outside the context of professional indemnity insurance, in emphasising that the dishonesty of one insured will not be held against another insured who is not complicit. That's the idea that Milady was referring to earlier, complicity, and obviously the precise nature of that depends on the policy. It's worth noting on the next column, column 2, again, where the headnote writer has put a line, that particular policy was not merely composite with the normal attributes of such, but had been specifically designed to provide cover to innocent insureds, despite the guilt of their close associates. And in light of Lord Justice Popplewell's observations, that's almost certainly the case with our policy, as I shall submit in a moment. Finally, before we come to the words of the policy, I'd like to refer, if I may, to tab 24 in the authorities bundle.
I just interject a moment,
Yes, sir.
just to say that I've been told that the live stream is back up and running.
I'm grateful. So this is Canon and McGurk, which is really the leading text on this area, professional indemnity insurance, by the late lamented Mark Cannon and Brendan McGurk. Page 229, please. Here, at 801, the authors refer to the policy that I was referring to earlier. It's not possible to obtain assurance against liability for one's own fraud or dishonesty. Implicit of the nature of insurance that loss caused by the deliberate dishonesty of the insured is not covered, just as no cover for any loss caused by willful misconduct. So that's the general policy in our submission. Axis don't agree, but that's our submission. And at 847, so page 244, the authors deal with the problem I mentioned a moment ago of attribution in the case of a company. When is the company to have that policy I just mentioned applied to it? As I said, 8.47, where the insured includes the body corporate, the position is more complicated, since in most cases, as in our case, it'll be the body corporate that's liable to the third-party claimant. Now, turning to page 247, at paragraph 8.54, the authors observe that the SRA minimum terms and conditions make specific provisions regard. They provide that a body corporate will not have any dishonesty or fraudulent act or omission imputed to it unless it was condoned or committed or condoned by all the directors in the case of a company or by all members for an LLP. And the authors say this maximises the protection for innocent insured in that the body corporate through which they practice will be insured unless all principals are complicit in the fraud or dishonesty, also maximises protection for clients of solicitors practising through bodies corporate who might find it hard to establish that they were owed any duty of care and tort by directors and so forth. So anyway, that's their view. And now, could I ask you to take out the core bundle? And turn in the core bundle tab 14, please. So these are the solicitors' SRA indemnity insurance rules that I mentioned earlier. This is common ground, so I'm not going to go to the precise wording, but the Annex 1 has the minimum terms and conditions in it. Sorry, Appendix 1. That starts at page 366. And the relevant clause in the minimum terms is at page 375, clause 6.8. And of course I hope you can see that clause, it's similar, not identical, and I'll come back to that on tomorrow. But as to attribution, as I recall, the wording is the same, 6.8b, the insurance must provide that no dishonesty attribution will be imputed to a body corporate unless it was committed or condoned by, in the case of a company, all directors, in the case of an LLP, all members. So then, could I ask you to go to tab 30 in the core bundle, please?
Tab 30 in the core bundle.
Yes, please, page 337.
With 13.
Tab 13. 1-3. So this is the, first of all, the schedule to the relevant policy. Note the name of the insured is Jirehouse Partners LLP, fourth entry, trading as Jirehouse and Jirehouse Trustees Limited, and as detailed in the proposal form. At page 341, at the top of the page is the start of the exclusions. The insurer shall have no liability under the policy for. And over the page 342, as we've already seen, you have clause 2.8, the relevant clause. The heading for that clause is fraud or dishonesty. I'm not sure it matters, but my learned friend suggested that was part of the construction. In our submission, if it's relevant, that's wrong, because on page 351, clause 5.10 letter E says, any headings are for ease of reference only and shall not affect the interpretation of the provisions within this policy. However, if we go back to page 342 and look at clause 2.8, one has to ask what is necessary to trigger this. And I'm sorry, I should in fact first have taken you back to page 340, please. We saw this yesterday, but this is page 340 at the top, clause 1.1. This, of course, is the key clause, the insuring clause. The insurer agrees to indemnify the insured up to the limit of indemnity against any claim resulting in civil liability, in a civil liability, where such claim arises from the insurer's professional business and then is either first made during the period of insurance or first made after the period of insurance but arises from circumstances notified. So the key point in our submission about this policy is, of course, like all professional indemnity policies that I've ever seen, it's a claims-made policy. This is ensuring the solicitor in the event of a claim being made, and there's a definition of what counts as a claim, which doesn't really matter for today's purposes. But that's relevant, we submit, when you turn back to 342 and clause 2.8 to ask what has to be condoned in order to fall within clause 2.8. As I said earlier, common ground burden of proof on this is and was on axis. So, first of all, there has to be a claim, because what is excluded as a claim in certain circumstances. Secondly, the claim has to directly or indirectly arise out of or in any way involve dishonest or fraudulent acts, errors or omissions. There's no problem with that here in our submission. In relation to surplus funds, the claim has been made and arises out of the dishonest act of Mr. Jones in authorising removal of the money, $14 million or so, from the client account. Similarly, there's no problem with these two conditions in relation to Dragonfly. A claim has been made, and the claim arises directly out of Mr. Jones's dishonesty in organising the execution of the mortgage and then removing the money drawn down on the mortgage. So there's no problem with directly or indirectly rising out of or in any way involving. It's a directly involving, and it directly arises from dishonest acts. The next question is, were those dishonest acts from which the claims arise committed or condoned by the insured? And as I showed you a moment ago, the insured here is the corporate bodies. And that's why 2.8b comes in, because no dishonest or fraudulent act or omission shall be imputed to a body corporate unless it was committed or condoned by all directors or all members. Now, the dishonest acts we're concerned about, the surplus funds dishonest act and the Dragonfly dishonest acts, were committed by Mr. Jones. So the question is, were those dishonest acts condoned by Mr. Prentice? That's the issue. That's what acts have to show in order to come within this clause. And under our submission, it is those dishonest acts, not anything else, that have to be condoned, albeit in the example I accepted a moment ago, if there were 99 cases of stealing client money that were condoned and another one, that would have been condoned. We accept that.
Well, something can be condoned in advance, can't it?
It could be.
So you can say, so one partner can say to the other, "I'm quite happy for you to take whatever you need from the client account."
You have carte blanche.
And so you don't know what monies.
Yes.
There's no specific condonation, but there's condonation.
Well, if
and that's all we're talking about here is if you are condoning a pattern or a number of things which give rise to a pattern, then you're deemed to be condoning the next one as well.
I would accept that in principle, Lord, yes, but I would submit that what has to be done, and this is an acutely fact-sensitive exercise, although it also involves considerations of law and respondents' notice, what has to be done, given that the condonation is not expressed, not a case of finding that somebody said, "I condone you taking client money whenever you like." What has to be done is to show, by conduct, that implicitly there was that condonation. And that's a difficult exercise. It's an exercise that requires very careful attention to the fact.
Yes. Well, as I understand here, what the judge said is Mr. Prentice didn't know about client monies being misappropriated. But to the extent that he was aware that something was going on, he thought that there may have been some misuse of client funds but not of the type or scale which was involved in this case. So that I think he's saying you can't take from any awareness of earlier misdealings, condonation of the misappropriations which give rise to the claims in this case.
I would
That's
respect
his alternative analysis.
Yes, that's his alternative. Yes, which arises if you were to overturn his primary findings of
Yes.
fact. Yes, and
That's an example. That's an example of where there may have been previous matters which may be regarded as having been condoned, but which doesn't mean that the matters giving rise to the claims were condoned.
Exactly, my lord, because the question is whether matters giving rise to the claims condoned. I accept that could happen impliedly, and it could happen by condoning a course of conduct, but it would have to be clear, and the course of conduct would have to relate to matters of the kind that gave rise to the claims.
Yes. Mr. Lawrence is putting very, very firmly the contention that because those earlier matters were condoned, he must also have been condoning the matters that gave rise to the claims.
And that the judge was compelled on his language to make such a finding.
Yes.
That's his case, yes.
Yes.
And we oppose it for multiple reasons.
Yes.
Well, but yes, those are the issues, my lord, certainly. Lord, I wanted to touch briefly on, although we've already dealt with it, so I'll take it briefly, this question of what does condone mean. And we've got the, might be worth looking at the dictionary definition just for a moment, in Authorities Bundle 2, tab 27. And I asked you to look at the last page of that entry because we've magnified the text, which was too small to read in the original copy. So this is one dictionary. The other dictionary definitions we have below were to similar effect. Definition from the Oxford, one of the Oxford dictionaries: condone. To accept behaviour that's considered morally wrong or offensive. The college can't condone any behaviour that involves illicit drugs. Or to approve or sanction something, especially with reluctance. Those arrested were released and the exhibition was officially condoned a few weeks later. The latter seems to be express condoning, as you might call it, and the former seems to be, in examples, the former seems to be, well, may have been condoning. But we would certainly say on the college example, since it's been referred to, that if the person at the college in charge of discipline is aware that there's smoking of cannabis because they can smell it in a room and they allow that to go ahead, they're condoning the smoking of cannabis. They're not condoning the taking of heroin. Those are different activities. One is a much lesser offence. It's illegal in some states of the United States. I'm certainly not condoning it myself, but it is considered less bad than the consumption of hard drugs. So what you've got to look at, if you're talking about condoning by silence, is exactly what it is that's condoned. But certainly this definition does, rightly in our assumption, show that condoning involves some degree of acceptance of misconduct. That's the relevant meaning for today's purposes. Clearly it's misconduct, learned friends talking about. Clearly there was misconduct by Mr. Jones to a greater or less extent. So, unless you wanted to raise anything more on that definition, Lord. If I may, I'll now move on to some observations with regard to the facts. Firstly in general, and then specifically the specific examples relied on unlearned friend. First, there's the point about the 7-month delay, which certainly took place. I'd simply submit that, as my Lord Justice Phillips observed in argument, there were transcripts. We've got the transcript of the cross-examination, and it can't be suggested that the judge had forgotten what the evidence was. There were numerous documents as well, and the trial was really all about one witness, Mr. Prentice. There weren't any other witnesses. Apart from Mr. Prentice giving evidence, there was a strikeout application on day one, which was not appealed, the decision on that. Then there was an opening. Then there was Mr. Prentice. Then there was a gap for closings, and then written closing and oral closing submissions. So there were no other witnesses at all. The whole focus of the condemnation case, which was the vast majority of the issue of the case, was had Axis made out its case with regard to Mr. Prentice.
I wasn't aware that in the course of Mr. Lawrence's submissions, he drew our attention to anything the judge had missed.
Not that I recall.
He didn't say there's this important document which the judge didn't refer to, or I may be misremembering, but I don't remember anything of that nature which one might expect if you're going to say, well, the delay meant the judge missed or didn't remember certain things that were important.
I don't remember that, but may I reserve my position till tomorrow, just in case I'm wrong?
Check the transcript.
We'll check that, and I'll address that first thing tomorrow, so I don't want to misrepresent the position.
No.
It certainly wasn't a centrepiece of the submission, no. Now, next, my lord, blind eye knowledge, and that's the sole basis of the appeal, and it was pretty much the sole basis of trial as well, not actual, but blind eye knowledge. And there, could I take you back to tab 16 in the authorities, probably authorities bundle 2, I am told. To group 7, here. Now, again, I'll try and take this briefly because we've looked at this passage and I've already referred to it a moment ago. But page 158 at the bottom, the Court of Appeal in the judgment of the court, below letter G, talks about blind eye knowledge and emphasises that it's not enough merely suspecting or negligently refraining to make further inquiries. Refers to the star C, the two conditions, the existence of a suspicion that certain facts may exist, and I submit that's a subjective finding of fact as to what was going on in Mr. Prentice's mind that is required for that. And the second is a conscious decision to refrain from taking any steps. This is the bottom page 158. And again, sorry, my lord, I was at the last 5 lines of page 158. The reference to Manisha Best shipping the Star C, and the last lines, the imputation of blind eye knowledge requires 2 conditions to be satisfied. The first is the existence of a suspicion that certain facts may exist, and the second is a conscious decision to refrain from taking any step to confirm their existence. And both of those require a finding of fact in our submission about what subjectively Mr. Prentice was thinking at any given time. That's clear over the page. Start the next page. The judgments also make it clear that the existence of the suspicion is to be judged subjectively by reference to the beliefs of the relevant person, and that the decision to avoid obtaining information must be deliberate. So those, as I submitted earlier, in our submission are paradigm examples of an area which is very largely within the province of the trial judge who saw Mr. Prentice over 2.5 days of Mr. Lawrence's cross-examination. And I referred earlier to the star C. You can see from the quotation, paragraph 60, that was, as I said, an insurance law case. And at the end of the quotation, Lord Scott was referring to the question of, he says, to allow blind eye knowledge to be constituted by a decision not to inquire, into an untargeted or speculative suspicion would be to allow negligence, albeit gross, to be the basis of the finding of privity, which was the relevant concept here. That, in my opinion, is not warranted by Section 39(5) of the Marine Insurance Act, which provides that the insurer is not liable for any loss attributable to unseaworthiness where, with the privity of the assured, the ship is sent to sea in an unseaworthy state. So we don't, I think, need to, certainly happy to produce tomorrow to assist the court for the Star Sea. I'm not sure we need to go into it, but the point I make is this idea of privity or complicity or giving your blessing to the specific wrongful conduct is implicit also in the Star Sea in the insurance law context. So, thank you. Now I'd like to turn just briefly to the circumstances in which the trial took place. I've already said only one witness, Mr. Prentice. 2.5 days of evidence. We've got the transcript. It's 85 pages long, though those are four small pages to 1 page. So, on my arithmetic, it's 350 small pages long. Sorry, 340. And as the court has observed, you've been shown a very small percentage of those in cross-examination, and of course, you've not seen Mr. Prentice in the witness box.
We haven't seen his witness statements either.
They're in the bundle. I don't think you've been taking them to them.
No.
That's right. The trial bundle, on our calculation, looking at the electronics overnight, was 15,000 pages long. That's just documents, not witness statements. Our own internal chronology for trial was 116 pages long, but maybe we were verbose. The core bundle had 1,850 pages. Bundle C, which was documents said to be relevant to trial, apart from Companies House documents, was 9,996 pages. Companies House documents were 5,256 pages, and Bundle H further documents, some of which were produced on the Friday before trial started on Monday, were 404 pages. So that's 15,656
Typical
pages.
commercial court action, in other words.
Yes, maybe. A lot of documents.
Well, unfortunately, there can be a tendency these days, but with electronic bundles, that everything goes in.
Yeah.
Yes, that does seem to be an unfortunate position, as we
Were
observed
they-
in relation to this very appeal.
Were the bundles electronic in this case?
They were.
There was a platform, was it? Was there?
Yes, it was Opus 2.
Opus,
Platform's called.
Well, I think experience shows these days every disclosed document tends to go onto the database, which I'm not sure how much one can draw from the quantity of documents.
Well, in our submission, what you can draw is that what you've got before you is about 1,000 documents on my arithmetic in all the bundles of documents, and you haven't been taken to the vast majority of those. So, in our submission, what you can
No,
draw
we've been shown a few documents which predominantly relate to not the matters giving rise to the claims, but to earlier matters.
Yes. And the judge, as to Dragonfly, the judge found that Mr. Prentice had nothing to do with he didn't see any document at all relating to the setting up of the loan. There's no challenge to that on appeal. So I know it's said that, Mr. Prentice must have thought, Mr. Jones must have thought that Mr. Prentice was the sort of person who would condone dishonest conduct because he allowed him to draft one letter about a lien in relation to Reno, but he didn't involve him at all in relation to Dragonfly. And he certainly didn't show him that the money had been paid away in relation to surplus funds.
So the case in relation to Dragonfly is because of his blind eye knowledge of the earlier matters.
Yes.
In 2016, 2017, he is deemed to condone fraudulently setting up a mortgage and taking away those monies.
Yes, I think there's also reliance on him not complaining fast enough in January 2019 when there was correspondence we saw earlier this morning. Although the fact is, the judge finds that on the 16th of March he was told that money had gone missing, and he resigned that day. No challenge to that finding.
Yes, thank you.
Now, my lord, the next submission I appreciate should be made extremely vast. I do understand that the court is completely familiar with the test for appellate restraint and so forth. So I simply wish to say that, as I understand it, it is common ground that the words of Lord Reed in Henderson and Foxworth apply to this case. And I'm not going to ask you to go to them in the authorities bundle. It seems unnecessary. They're quoted in Abliazov at tab 14, paragraph 43. It must either be, this is Lord Legate's quotation, I think. It must either, Lord Justice Legate, it must either be possible to identify a material error in the judge's process of reasoning, such as a material error of law, Axis don't allege that at all, or the basis, or the making of a critical finding of fact which has no basis in the evidence, or a demonstrable misunderstanding of relevant evidence, demonstrable misunderstanding, or a demonstrable failure to consider relevant evidence. Those are the relevant parts of the quotation. All it has, or if the question is simply one of weight to be given to relevant evidence, which is expressly what ground one of the grounds of appeal asserts, applying the wrong weight, the appellate court must be satisfied that the judge's conclusion cannot reasonably be explained or justified. No reasonable judge would have reached it. And at para 37 of Abliazov, Lord Justice Legate added that what significance, if any, should be attached to the fact that a witness has lied falls squarely within the province of the judge, whose role it is to find the relevant facts. My Lord, those observations are reiterated in a recent decision in the Authorities Bundle tab, Volume 2, tab 19, in the Volke and Volke of Lord Justice Lewison. Paragraph 2, this is a 2022 decision of the Court of Appeal, to which Lord Justice Mayles and Lord Justice Snowden were also agreed with the judgment. Paragraph 2, this is about an appeal on the pure question of fact, which in our submission is this case, as part of this case. Of course, 2(1), appeal court should not interfere unless satisfied the judge was plainly wrong. The next paragraph either has been read out by Mr. Lawrence or by me effectively. The next subparagraph, an appeal court is bound, 3, an appeal court is bound unless there is compelling reason to the contrary to assume that the trial judge has taken the whole of the evidence into his consideration. The mere fact that a judge doesn't mention a specific piece of evidence doesn't mean that he overlooked it. Again, at the end of 4, the weight which he gives to evidence is preeminently a matter for the trial judge, although just before that it said not all the evidence needs to be discussed in the judgment. 5, if it's a question of failing to give rash, balanced consideration to the evidence, which is certainly ground one of appeal, that can happen only if the judge's conclusion was rationally insupportable. So that's the test my learned friend has to make as to giving wrong weight to pieces of evidence. And little 6, an appeal court should not subject to judgment to I think that should say to too narrow. Sorry, should not subject to judgment to narrow textual analysis, nor should it be picked over or construed as though it was a piece of legislation or a contract. And then at the last page, page 10, paragraph 65, Lord Justice Lewison observes that this appeal demonstrates many features of appeal against finding of facts. It seeks to retry the case afresh. That, in our submission, is largely what's happened. Certainly, my learned friend's skeleton argument. He criticised the judge in relation to almost every finding of fact on which he lost. The only exception is the finding that Mr. Prentice was made a partner, and of course, that finding helps him in his case that Mr. Prentice had greater responsibilities. So practically every other finding, if a finding went against him, he says it was it's appealable, and if it was in his favour, he says it should obviously be upheld, and it's the building block for his appeal. There's almost no scrutiny, no filter process between those two categories. Little 2, it rests on a selection of evidence rather than the whole of the evidence that the judge heard what I've elsewhere called either. Well, that's exactly the point that I know the court has in mind and I've just been referring to. And then it seeks at 3 to persuade an appeal court to form its own evaluation of the reliability of witness evidence when that's the quintessential function of the trial judge who's seen and heard the witnesses. Well, again, that's exactly what is being attempted in our submission by Axis on this appeal. And it seeks to persuade the appeal court to reattribute weight to different strands. Well, that's what the grounds of appeal in some cases expressly say that the Court of Appeal should do. And the implication of this paragraph is, of course, that all of those activities are inappropriate steps on appeal. My Lord, I'd like to refer to the core bundle now, and if I may, and tab 10. So this is the re-amended defence and counterclaim of Axis. The initial defence didn't plead condemnation at all. That only came a year or so after the initial defence. The initial case was based, and the pre-action correspondence was based only on the proposition that Mr. Prentice was not a partner, it was a sham partnership, a point that's not appealed today. And then, of course, this defence was, and counterclaim was re-amended, and we have to go to the end. I think it's about a month before trial in, I think it was June of, yes, I believe it was on the 1st of June 2022, according to my note. Trial was in July 2022. And as you can see, there are 60 pages to this document, and there are many, many allegations, some of which were abandoned, as I recall it, more or less at trial. There's a case, a company called L&E. That doesn't seem to be, certainly not, perhaps contrary to my earlier submission, certainly not part of the appeal. I don't think it was part of the closing submission, but I may be wrong about that. So this just demonstrates the sea of allegations which the judge had to deal with. Of course, they were somewhat focused by the time we got to the end of the trial by closing submissions. But this was the context which the judge had to consider in writing his judgment. Another factor to bear in mind is that when Axis say that we don't know, as was said some of the time yesterday, we don't know whether money was stolen or where it had come from or where it had gone. Axis had spent or planned according to its cost budget I don't think we need to look the reference up, but it's the record. It's supplemental bundle 2, tab 65, page 301. Its cost budget shows it intended to spend £710,000 on disclosure. So it's not as if Axis didn't have really quite a large number of bites at the cherry in terms of preparing this case, and that ties into the remarks elsewhere of Lord Justice Lewison that the trial is not a dress rehearsal, and in fairness, this is in Abyazov as well, another reason for appellate restraint is the unfairness of a party having faced the trial, having won the trial, then having to re-meet many of the allegations all over again on appeal. My Lord, I'd now like to refer a point taken at paragraph 36 of our skeleton argument. That's to do with the question of motive, which we also touch on in the respondent's notice, so I'm not sure the fact that we did if we needed to. And this point is, in summary, that in cases of fraud, and we say, contrary to what the Land Company said yesterday, and I'll address this in a moment, we say what is being alleged against Mr. Prentice is close to fraud. It's not the same as fraud, but it's pretty close, because what they're saying is that he was complicit in taking client money. He was approving taking client money. Now, for a solicitor, that's an extremely serious allegation to make.
Well, it's saying he was not innocent.
Yes, yes. So it's similar to fraud. And the point we make is simply this, that in the context of fraud, what the courts have said is that it is a very material factor to consider the question of motivation. Now, Mr. Prentice was born in 1978. The reference is Supplemental Bundle 2, tab 72, page 362. I don't think we need to look it up. That's in his cross-examination. So in 2018, he was aged about 40, and he was a lawyer. And obviously, any lawyer aged 40, save in exceptional circumstances, would be hoping to work for at least another 20 years. Now, Axis's theory of this case, insofar as there is one, is that Mr. Prentice was getting nothing out of it. Nobody suggests for a moment that any of the stolen money was going to Mr. Prentice or was intended to go to Mr. Prentice.
Some of it may have been used to prop up the firm, and the firm started getting into financial difficulties. There was an element of robbing Peter to pay Paul, and if the firm didn't exist, he wouldn't be working for it.
Well, he left the firm in March of 2019 on his evidence when he, and the judge's finding, when he learned about the money being taken. So it's not as if he was unwilling to leave the firm. He left it.
I mean, I don't think this is your strongest point with respect, because of the judge's findings of other types of acts of dishonesty on the part of Mr. Prentice. On any view, he was quite willing to engage in behaviour which would be reprehensible for a solicitor and might lead to him being sacked if it were to be found out and his principal was honest. So the fact that he's not going to get any share in the proceeds is neither here nor there. He was prepared to act dishonesty in certain respects. The judge found that he wasn't in this, that there was a line to be drawn. Even with his very low moral compass, as the judge put it, he drew the line at stealing client funds. You say that was something he was entitled to come to, and you may well be right.
He was entitled to come to. We say, I won't labour the point, but we do submit that if Axis were going to assert, as they were asserting, that Mr. Prentice was complicit in wholesale theft of client money, They should have put something to him about motive in cross-examination, but they didn't. That's common ground. I think Mr. Lawrence said yesterday there was no cross-examination about motive. His answer to it yesterday was, firstly, that condonation is not the same as fraud. Well, I've addressed that submission. And secondly, that it was obvious that Mr. Prentice might have to ask awkward questions. Well, there was no cross-examination to the effect that Mr. Prentice didn't want to ask awkward questions that I can recall, but I will check that. I might be wrong. So
well, you can certainly make the point that in relation to the acts which give rise to the claims, what motive did he have to condone those specific acts of stealing huge amounts from the firm's clients when he was getting no personal share of that? So I think you can certainly say that in relation to those matters, but I think the case against you is that the condemnation was of the pattern which is really developed in relation to the earlier matters, where it's clear he did act wrongfully and to some extent dishonestly. And once you've established that he did do that, then the question of motive to some extent has disappeared. I think that's what my lady was making.
Yes. I'm grateful. I don't seek to challenge that, I respectfully say. On one view, the judge does make findings about motive, as I shall submit shortly, which is that his theory of what explains Mr. Prentice's behaviour, as you will have seen from the judgment, is that he didn't have motive in the sense of motive to participate in stealing $14 million, but his motivation in terms of why did he tell lies, that the judge does do.
Yeah.
He doesn't, it's fair to say, he doesn't address the question of did he have any motive to be complicit in the theft of $14
Trying
million.
to distance himself, saving his own skin, etc.
That's the motivation.
Motive for telling lies, yeah.
Yes, that's right. So, my lord and ladies, I'd like to start now on the specific instances that were relied on by my learned friend. First of all, we had reference to Mr. Young, Ms. Strickland Coutinho, and Mr. Elgood.
Short answer to that, clear bill of health from the SRA.
Clear bill of health from the SRA in relation, certainly expressly, it appears in relation to Strickland Coutinho and Elgood, who were a few months before the SRA clean bill of health. In relation to Young, the SRA don't seem to have done anything. But the other answer is no misconduct alleged against Mr. Prentice. Not even alleged that Mr. Prentice was aware of any of the things alleged. Because on the findings, on the evidence before the court, and if necessary I can use chapter and verse for this on Monday, the fact of the evidence was that Mr. Prentice was a litigator and Mr. Jones wasn't. And most of these allegations made by Mr. Young, Mr. Strickland Coutinho and Mr. Elgood relate to non-litigation matters. Now, the only caveat that is Ms. Strickland Coutinho does refer in one page of her report to a litigation matter involving Mr. Prentice, and she alleges that it was negligently carried out, putting it to slice. There's no suggestion of any knowledge of wrongdoing on the part of Mr. Prentice. Now, the next point taken in Axis's skeleton, paragraph 25, but not orally, was reference to a defamation claim. And what was said was that Mr. Prentice acted in relation to a claim by Mr. Jones, a libel claim of some kind, defamation claim I should say, and therefore he should have known that Mr. Prentice was up to no good. Now, the particulars of the claim were signed by Sir Edward Garnier, QC MP, the former Solicitor General, I think I'm right in saying. What happened was something was put on the internet. Mr. Jones wanted to sue. He did sue, the case was settled on the footing that the defendants didn't defend the claim. And that's an example of allegation that Axis made, even on appeal they make it, and then abandoned in their oral submissions. Just like, in relation to, or to some extent like, their position in relation to subparagraph B as to aggregation, where it was pleaded, not advanced at trial. Then it was said that it was a basis for appeal because the judge was plainly wrong not to have accepted an argument that was never made to him. And then that was abandoned at lunchtime on the first day of the appeal. One of the island-hopping features of this case is that the judge was entitled in our submission to take account of submission of allegations made by Axis which were extremely weak and or not pursued. The next matter I'd like to refer to is paragraph 55 of the judgment. And tab 7 of the core bundle, page 134. Now, this is a matter that the learned friend referred to yesterday, and it certainly, I would accept, contains findings, of course, which are critical of Mr. Prentice. As it happens, in paragraph 52, where it said at the end of that second last sentence, Mr. Prentice suggested at the time that Jirehouse CFS be allowed to go into some form of insolvency process. As it happens, though we haven't appealed on this basis, that wasn't pleaded, as we can see. And at 53, where it said that Mr. Prentice, line 2, was aware that Jirehouse CF was subject to a £1 million debt from Mrs. Lawrence, that, as we can see, wasn't pleaded either. But I accept the point. We haven't appealed on those bases. We accept that this was an overall judgment. The judge was entitled to come to conclusions, and we're not seeking to overturn it. And, of course, the judge makes findings at 54, makes a finding contrary to Mr. Prentice at 55, but at 54, on what was the key question, and is the key question according to Axis's own skeleton for this appeal, holds that he doesn't consider that Mr. Prentice saw or should have seen that the pressure was significant enough to lead him to assess, as Axis argue, that there was a risk that Mr. Jones might use client funds to meet the liability. So that was the issue raised by Axis, and that's the key issue for purposes of the appeal. Blind eye knowledge of using client money for Mr. Jones's own purposes. Well, at the risk of certainty of repeating what I said earlier, as Lord Justice Leggett says, it was for the judge to decide preeminently what weight to apply, to give to his findings that Mr. Prentice had either lied, or we would say, if it's not a lie, behaved improperly. That was for the judge to decide. And in our submission, none of the Henderson-Foxworth criteria, which I read out earlier, can be satisfied in relation to the finding at paragraph 54. There's no misunderstanding of the evidence alleged. The judge has actually made findings that are contrary to Mr. Prentice. He's taken into account the evidence given. He's taken into account Axis's contention, and he's rejected it. Axis, on this point, lost.
Well, we haven't seen any of the evidence of Mr. Prentice's response to this in his witness statements, nor the cross-examination in relation to it.
No.
Not sure how we are in a position to find that the judge wasn't entitled to reach this conclusion.
I respectfully agree, Lord. Yes.
You're not going to take this to them.
I'm sorry?
You're not going to take this to them.
I wasn't. No.
No. Well, why would you? Why would you?
No. No, I'm not intending to. No.
No. So I'm just, for my part, I'm at the moment unsure what material we have, which would enable us to come to the conclusion that that wasn't a view the judge could take.
Yes, well, my lord, I can't really add to that point. I simply
Should
say...
we move on to the next one then?
Yes, I'm grateful. In that case, let me move on to the Reno matter. Now, in relation to this, we looked yesterday, so I'll take it relatively quickly, but I want to pause once we get to Mr. Prentice's involvement. The first point is that the payment into Jirehouse was in June 2016. 21st June, the letter at supplemental bundle tab 8, page 46, saying that the Jirehouse trustees will hold 400,000 in their general client account, and 27th June 16, same bundle tab 11, page 81, that money was paid out. Was paid to the Jirehouse trustees limited client account for John Street Bridge Finance. So that appears to be the theft of the money or the removal of the money. So that's a year before the letter we're concerned with, drafted by Mr. Prentice, and it is not until February that there's any involvement of 17, many months later, that there's any evidence of Mr. Prentice being involved in this matter at all.
Well, the judge has made a finding that he wasn't actively involved until June.
Yes, my lady, I'm grateful. So we can ignore in that case February, which I was just going to briefly touch on. So we come till a year later. Now, the first point I want to make is that the judge was entitled to bear in mind, and that this court, should have been considering Land Company submission, is entitled realistically to bear in mind that those who are partners in solicitors' firms don't necessarily walk around thinking to themselves every day, in what way has my partner misled me and fraudulently attempted to stop me noticing that hundreds of thousands of pounds worth of client money have been stolen? That is not an everyday occurrence in most solicitors' offices, happily. It's all very well with hindsight to say, well, Mr. Jones is in jail, as he is, something like 10 years, for multiple breached thefts. But of course, if he was a fraudster of the kind which it would appear he undoubtedly was, he might have taken the view that he didn't want Mr. Prentice to know about it.
Well, Mr. Jones wasn't going around wearing the clothes of a fraudster. He was going around wearing the clothes of the principal of the firm, who was running the show, and everyone was dependent upon him and his skills for its prosperity and survival.
He was the boss.
Yes.
He founded the firm, as far as I know.
The judge has found, accepted the point that Access made, that James didn't sort of go around trying to conceal anything from Prentice.
I'm sorry, which paragraph is that?
63.
Thank you. Well, yes, I accept the first sentence of 63, but there is also the second sentence of 63.
He accepts the point, but not that he reached any conclusion. But that ties in to 62, which does have a slightly puzzling, I must say, just speaking for myself, that the judge finds that he read down the email chain, so he rejects Mr. Prentice's evidence that he didn't. He gives a good explanation for why, even in the limited role of drafting the letter, he would have read the email chain. And he goes on a bit later on to say that, in fact, his involvement was greater than that, right? Yeah. And that he made some false statements to cover his own back. He does make a finding that he gave it little attention. Yeah. And I find that slightly puzzling on the basis that if you've got a witness who says, I did not read it at all, how can a judge come to the conclusion that he did read it, but he didn't give it very much attention?
Could we look at the letter of 22nd of June, please?
Yeah. Which
is a supplemental bundle, I think probably 2, tab 17, page 96.
Sorry, could you give me the tab again, please?
Yes, tab 17. page 96.
Yeah.
Now, what the judge says, this is the letter as sent out, so having been on the judge's findings drafted by Mr. Prentice, that's 71 of the judgment. These, of course, are in a section, actually, effectively, a section compartment from 71 to 75, where the judge is stepping back and saying, right, I've recorded the facts, now I've thought about it, here are my findings. As he says at 70, it's based on having heard Mr. Prentice's evidence and considered the position and the documents. So he does hold that Mr. Prentice was the typist of the letter, was not simply the typist, but was also the draftsman, under instruction and on information from Mr. Jones. Now, if we look at the letter, one has to ask, what was the reason why Mr. Jones is likely to have engaged Mr. Prentice, a litigator, in drafting this letter? And in our submission, the reason for that is that what this letter is mostly about is the assertion of a lien, or lien, however you pronounce it. As it says in paragraph 3 on page 96, this firm is currently exercising a lien over the good faith sum in respect of unpaid fees, which are currently well in excess of £300,000. There's talk of somebody called Mr. Wilson's consent to release the funds. There's a reference, numbered paragraph 1, to events since late 2014, that is settlement. Then, numbered paragraph 2, there's an assertion of being entitled to exercise a lien. And there's reference to engagement letters, all of which have been set out earlier. And then there's a discussion of the basis on which the money was being held. There's reference to correspondence in June of 2016.
Yeah, so if anybody had actually gone to that correspondence and looked at it, they'd realise the money was being held in escrow on trust for the client, and there was no business in it putting a lien on it.
Well,
particularly if they were a litigator.
I would respectfully submit we don't know the answer to that unless we actually look at that correspondence, which we don't have before us, as far as I know, as I can recall. But the main work of doing this letter was to assert entitlement to lien. That must have been why Mr. Jones, Mr. Prentice, the litigator, was involved. The main question which this letter was answering was not, do you still hold the money in your client account? The likelihood is, or at least the judge was entitled to proceed on the footing, that Mr. Jones instructed Mr. Prentice and said to him something like, well, this is my matter, I've been dealing with it last year, the money's on client account, please deal with the question of whether we can assert a lien or not. As I recall it actually, and this is an island hopping point, we had evidence, documentary evidence at trial about a trip to see counsel to advise about this. I can't remember the precise detail now, but I think that was the case.
We saw reference in the documents to taking advice from counsel.
Yes.
On the lien.
Yes. And I suspect that happened after this letter, but it was in that context, done in that context. So the judge in our submission was entitled to proceed on the footing that he did in his careful assessment and findings. That Mr. Prentice did not draft a representation about client monies which he knew or had reason to be false, the representation being at the start of the third paragraph, as we heard yesterday. I should say, or I'd like to submit, just briefly before 1 o'clock, the circumstances of this drafting of this letter and the question of whether Mr. Prentice had actually made up his evidence about there being an internal accounts document was the subject of submissions at trial. In our closing and oral written submissions, we pointed out that although word searches had been done for words such as Reno, and we were told we'd been given all documents which had Reno in them. In fact, it was obvious from the documents we did have that this was not the final draft of the letter, and that we did not have the first draft of the letter, which one would expect to have the word Reno in it. What happened was that at 3:30 p.m, after I had finished my closing submissions, and my learned friend had gone previously in accordance with the commercial court practice, we were told that more documents had been found. We were told that the draft of this letter, the first draft, had been found, conveniently after we'd finished our closing submissions. And we were told that by accident, it had accidentally been marked confidential by those doing the reviewing. Now, I'm not criticising them, no doubt they had a very difficult job to do, but the fact is, we had not been shown a document which quite clearly was relevant to the case, being the first draft of this letter, which was pretty much the centrepiece of Axis's case. We were only given it after the trial had concluded. We had to have further submissions in writing about the significances. And our point was, if your process of disclosure has not found a crucial document, in difficult circumstances, the firm had been intervened in, I fully accept individual extra independent counsel had to be found to review everything so that documents the subject of other clients' privilege weren't disclosed to Axis and then to us. I can see that was a difficult, time-consuming process. But that cast doubt on the proposition that if an internal accounts document had existed, it would have been found.
Well,
now,
true, but the judge found against you on that.
I accept that. The judge found against us, and we haven't appealed. So I fully accept it. I'm just saying, as a matter of island hopping, we've got to bear in mind that these findings were not absolutely written in stone before the trial. But I do accept we didn't appeal on that basis. We could have done. We chose not to because we saw the judgment as an overall balanced and fair, nuanced judgment.
Well, ultimately, I mean, it was only more grist to the mill. The judge also found that it was objectively improbable that Jones would have created that sort of document with somebody else assisting him, and he'd have needed somebody else's assistance to do it in order to deceive Mr. Prentice. Seems to me to be an equally strong reason why Mr. Prentice was lying about it. Why he was lying, of course, is a matter that the judge made his findings on, and you rely on that.
Exactly, we rely on his findings. And the final point I'd make is, and I'll come back to this tomorrow, the finding to the effect that Mr. Prentice, insofar as he told lies, was after the event trying to excuse and distance himself from matters which he could then see were embarrassing, potentially embarrassing. That's not just a finding made in relation to this incident. That's a finding made in at least 2 other places. It's clearly a carefully considered finding of the judge in relation to multiple evidences of evidence, all of which my learned friend has to overturn to succeed on this part of the appeal. My Lord, would that be a convenient moment?
Yes, it would. So we'll resume again at 10:30 tomorrow, and it is we have to finish by lunchtime.
Certainly.
I don't know if you've agreed a division with.
I think we have a mind. I think we have agreed one. It may be that alterations are going to be suggested.
We haven't fallen out over timing so far, my lord, so I don't think we will.
Very well. Thank you very much.
All rise if able.
Patrick